Ladies and gentlemen, welcome again. Due to the fact that I was not participating in the morning session, my name is Bogdan Góralczyk. Forget the last one. The first one is okay. The last one you can brutalize as you wish. I'm used to, so no problem. We have a double session, so be prepared to have a double trouble here. A very specific one. We get started half an hour later according to the schedule, but I will try to manage with all my skills to finalize according to the schedule 6:30, which means that our kind panelists have 15, maximum 17 minutes. If they start to argue with me, they will have 10 minutes. So this is very democratic, and we used to use this way. For the first part of this panel, we have 4 panelists. They are attending. And look who is on the left of my side. He is Mr. Eden. So even extraterrestrial is already with us. Eden is with us. We survive. So he will get started. Afterwards, starting from the right-hand side, Mr. Evgeniy Voronin, a famous MGIMO, so official diplomatic approach of Russia will be presented, I understand. Afterwards, doctor. Why doctor? I will call him professor. You are Professor Christian Henderson from University of Liverpool, representing, like Mr. Eden, the islands from the distance. And finally, last but not least, Antonello Tancredi, University of Palermo. This is the story, yes. What he is representing Palermo. This is the question. But let's get started. So without further ado, just one sentence. I'm not a lawyer, but I try to be legal, which means strict to the rules, and rules were already provided. 15 minutes, maximum 17. If something is wrong, 10 minutes. Okay, thank you. Mr. Eden, the floor is yours.
Thank you. As Bogdan indicated, my name is Paul Eden. I'm from the University of Sussex. I know that many of you have access to the internet, so the paper I'm speaking to is available as a handout electronically via my Academia EDU page. So if you do Paul Eden Law Academia EDU, you'll come to conference presentations, and so a 2-page handout, Crimea and the Concept of Aggression, is available electronically at that site. And obviously, if you don't have electronic sources here, you can pick up that later. I know some of you are tweeting, so if you're tweeting about the conference and you want to say how awful I am, my Twitter account name is Paul Albert Eden, so feel free to tweet abuse to that account. So I've been asked to speak about Crimea and the concept of aggression, specifically not the crime of aggression. I know that we have speakers on that particular topic. So I'm speaking about Crimea and the concept of aggression, and I've spoken to Chris Henderson. I know that he's speaking about the relationship between the use of force and aggression, so I intend to tiptoe around that. As I'm the first paper, and I know that we have people from a variety of backgrounds, some experts in this areas, and some happily not lawyers who are coming to this for the first time, I'm going to give some of the legal background to the issues here. And it's been indicated, obviously, that when we're having this discussion that we need to be talking about international law and the sources of international law, which the international lawyers in the audience don't need reminding, starts with in Article 38(1) of the Statute of the International Court of Justice, and we can have a debate on the canonical status of that, but obviously that tells us that we start with treaties, and then we move to custom, and then the general principles law of civilized nation, and then we move to distinguished publicists, who I learned from this morning include Rousseau. And so let's look at the treaty obligations between Ukraine and Russia that would give us a concern about the presence of Russian troops on the territory of the Ukraine, or more specifically Crimea. Firstly, as part of the breakup of the Soviet Union, there was a protocol to the Commonwealth Pact, which was done at Alma-Ata on the 21st of December 1991, known as the Alma Alta Declaration, which expressly acknowledged the various parties' territorial integrity and the inviolability of existing borders. So that was the first acknowledgement of Ukraine's existing borders. In 1994, as part of the accession of Ukraine to the 1968 Nuclear Non-Proliferation Treaty, the United States, the United Kingdom, and the Russian Federation signed a memorandum on security assurances in Budapest that reaffirmed the parties' commitment to Ukraine, and I quote, "in accordance with the principles of the Conference on Security and Cooperation in Europe Final Act, to respect the independence and sovereignty and the existing borders of Ukraine," that's Article 1, and again quoting from Article 2, "to refrain from the threat or use of force against the territorial integrity or political independence of Ukraine," that's Article 2. I would briefly point out that China and France gave rather less binding assurances to Ukraine at that time, and it has been pointed out at least one of the blogs to the extent to which the United States and the United Kingdom might be have positive obligations under these security assurances to do something positive in response to the events in Crimea. I haven't seen any strong arguments to suggest that the memorandum is strong enough to have given a positive obligation on either the United States or the United Kingdom to come to the assistance of Ukraine in this situation. The reference to the final act of the Conference on Security and Cooperation in Europe is interesting, and I have a rather nasty habit of going back and actually reading treaties. So I had a look at the final act just to look at that, and that final act affirmed that the participating states would refrain from the threat or use of force against the territorial integrity or political independence of any state, and that no consideration may be invoked to warrant resort to the threat or use of force in contravention of this principle. It is, however, worth noting that the CSCE final act also contains acknowledgement that the participating states, quote, "consider that their frontiers can be changed in accordance with international law, by peaceful means and by agreement." So certainly in accordance with international law, but the second part of that after the comma, "by peaceful means and by agreement," suggests that agreement might not be entirely peaceful, if you see the argument I'm making. So from a lawyer's perspective, and I was a tax lawyer back in the day, so peaceful means and agreement could be alternatives. They would have to be in accordance with international law, but they could be alternatives. It makes me nervous as an international lawyer when I see an "and" like that. So, but we can have a discussion about that. I haven't seen that in the literature so far. So finally, the reference to the 1997 Treaty of Friendship, Cooperation and Partnership between the Ukraine and the Russian Federation, which was executed in Kiev on the 31st of May 1997, required the parties to, in Article 2, respect each other's territorial integrity and confirm the inviolability of the borders existing between them. Although the 1997 agreement between the Russian Federation and Ukraine on the status and conditions of the Russian Federation's Black Sea Fleet stay on Ukrainian territory, extended in 2010 for an additional 25 years, permitted the presence of Russian troops on Ukrainian territory, Article 4.1 of this agreement placed strict limits on the number of military personnel, and Article 6, subsection 1 stated that military formations carry out their activity at stationing locations in accordance with Russian Federation legislation, respect Ukraine's sovereignty, abide by its legislation, and do not allow interference in Ukraine's internal affairs. So there's the situation in which there's the bilateral agreements, and in one case the Alta Declaration, a multilateral agreement which requires the parties to respect existing borders, and the 1997 Status of Forces Agreement, which controls the presence of Russian troops on Ukrainian and specifically Crimean territory. I don't think I need to go over the section dealing with the factual situation. I know that's disputed. The one thing I would draw attention to is obviously the one, I think, genuine concern which was expressed was the proposal on the 23rd of February 2014, 2 days after the flight of Viktor Yanukovych, the motion to repeal the 2012 law on the principles of state language policy, which was carried by 86% of the Ukrainian parliament. I know that there will be different views as to what the effect of that law was, and the move to repeal the 2012 language law was largely portrayed in the Russian media as an attempt to ban the Russian language It provoked negative reactions in Crimea and in some regions of southern and eastern Ukraine. It became one of the key focuses of protests against the new post-Yanukovych government. So it's really from the 23rd of February onwards that we can see tensions between pro-Euromedian and pro-Russian protesters in Crimea. As early as the 24th of February, Russian flags are starting to be erected at various sites by small groups of protesters. And as early as the 25th of February, a protest demanding a referendum on Crimea's independence was held outside the Crimean parliament. On the 27th of February, 60 pro-Russian gunmen seized Crimea's parliament building and raised Russian flags. And the seizure of the Simferopol and Sevastopol international airports early on the 28th of February was carried out by approximately 100 armed men who, it has been alleged, were Russian Black Sea troops. On the 28th of February 2014, a Russian Federation missile boat blocked Balaclava harbour, where ships of the Ukrainian Sea Guard were stationed. It has also been alleged that up to 2,000 Russian airborne troops were also flown in on the 28th. I mention these things because obviously aggression requires acts, and those are the acts which I think we can refer to with some degree of certainty. I of course accept that facts are contested. So that we're talking at the 28th, so that moves us to the 1st of March, where this is the first time the UN Security Council in open session is dealing with this at the 7,124th meeting of the UN Security Council. And the representative of the Russian Federation, Mr. Chikin, quotes from the request sent by the Russian President to the Federal Council regarding the proposed deployment of armed forces of the Russian Federation on the territory of Ukraine. In the two-page handout, I have the extract. I'll spare you. It's basically it's the extraordinary situation and the threats to the lives of Russian citizens, our compatriots and members of the military contingent of the armed forces of the Russian Federation deployed in conformity with international agreements on the territory of Ukraine. So effectively the justification given for the deployment or the request to the Federal Council for permission to deploy Russian troops was the threats against the lives of Russian citizens and the members of the military contingent of the armed forces who are present on Crimean territory. At a subsequent meeting on the 3rd of March 2014, the 7,125th meeting of the UN Security Council, Mr. Churkin produced a request for armed Russian intervention in Crimea from the ousted Ukrainian President Viktor Yanukovych, which was dated the 1st of March 2014, to rebut the assertion that Russia's actions constituted a form of aggression. So that's the factual background. So let's now deal with the concept of aggression. I'm going to speak rather briefly and limit my remarks to the 1974 definition of aggression. The one thing I would say is obviously the history of the Soviet Union in developing the definition of aggression is something which I would commend to your attention. And if, like me, you lack great ability in Russian, then there's a recent PhD thesis by Christy Scott Bartman, Lawfare, the use of the definition of aggressive war by the Soviet and Russian Federation governments. It has been published, but I would actually recommend you to use the dissertation version, which you can get for free rather than paying money, and there is no difference between the dissertation version and the version published by Cambridge Scholars Press, which is based in Newcastle and Tyne and has no links with the University of Cambridge. It's a good book, and I respect the arguments, but I'm not sure that you're getting any benefit from buying the book version. Just download the PhD.
Is that legal?
I think it probably is. Private use. It certainly is with the United States. Don't sell. So, private use only, please. So I can't deal with history, but I think it's fascinating because you can actually see the 1974 definition can be traced back to Soviet recommendations from the 1930s. So if you want to do the...
Don't go to 1930s.
5 minutes. So let's start with the 1974 definition of aggression. Article 1 states that aggression is the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations. Article 3A of that definition includes any military occupation, however temporary, or any annexation by the use of force as qualifying as an act of aggression. And in Article 3C, the blockade of ports or coasts of a state by the armed force of another state are also acts of aggression. So one missile boat gives you a potential aggression problem if you have a blockade. Article 3E of the 1974 definition of aggression notes that the use of armed forces of one state which are within the territory of another state with the agreement of the receiving state in contravention of the conditions provided for in the agreement, or any extension of their presence in such territory beyond the termination agreement, qualifies as an act of aggression. So it's okay to have your troops there, but if you do things with your troops that the basis on which they're there does not permit, then you've committed an act of aggression. And finally, this is relevant for Crimea, but also vitally important for the situation in eastern Ukraine, is Article 3G, the sending by or on behalf of a state of armed bands, groups, irregulars or mercenaries which carry out acts of armed force against another state of such gravity as to amount to the acts lifted above or its substantial involvement therein. So those are the bases on which we would have to establish an aggression. I think that from what I've told you about the facts, that we could make an argument that the takeover of the airports by people, I think it would be difficult to deny now, we're not official military forces of Russia, even if they weren't wearing the badges, a blockade, and of course the occupying there and the use of their armed forces outside the status of force agreement are all things which I think you would be hard pushed not to find constitute the definition of aggression. Just briefly, there seems to be consensus among the international humanitarian lawyers that this did constitute an international armed conflict, because under Common Article 2 of the 1949 Geneva Conventions, the application of international humanitarian law is applicable to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance. And as I note, I haven't yet come across, but I'm sure you'll draw my attention to it, an IHL lawyer who doesn't think that the limited clashes between Ukrainian and Russian forces met that threshold. They all seem to be in concurrence on the grounds that you don't want to have a vacuum in these situations. President Putin's request for authorization to deploy armed forces of the Russian Federation on the territory of Ukraine on the 1st of March 2014 can be characterized as a threat of force. To merely ask for your forces to be given the authorization, I think, can reasonably fairly be characterized as a threat of force. In retrospect, it now seems clear that most of the unidentified armed men were members of the Russian armed forces, and this was indeed acknowledged by President Putin on the 17th of April 2014 during a nationally televised call-in program, and thus that these actions constituted a direct act of aggression. The United Nations General Assembly on the 27th of March 2014 adopted a resolution, Resolution 68/262, entitled The Territorial Integrity of Ukraine, with a voting record 100 in favour, 11 against and 58 abstaining, which recalled the obligations of all states under Article 2 of the UN Charter to refrain from the threat or use of force against the territorial integrity or political independence of any state, and also the 1970 Friendly Relations Declaration. And in paragraph 2 of that General Assembly resolution, they stated they called upon all states to desist and refrain from actions aimed at the partial, total disruption of the national unity and territorial integrity of Ukraine, including any attempt to modify Ukraine's bordering through the threat or use of force or by other unlawful means. In final conclusion, it's only aggression if it's contrary to international law. So if your armed force is permitted by international law, then it's not aggression. So the justifications for the use of armed force are firstly the threats to Russian citizens, and secondly the request from the ousted Ukrainian President Yanukovych, by then in exile in Russia. Aggression requires the use of force to be inconsistent with the Charter of the United Nations, but the attempt to invoke Article 51 of the UN Charter to justify the use of force to protect nationals abroad has not met with general support, and we can explore that in the questions. Likewise, the consent of political figures who can be assumed to be subject to coercion and/or who no longer enjoy the support of their populations is a discredited argument. The self-determination argument is similarly flawed. We discussed that in the morning, and I'd be happy to return to why I think it's flawed in the later in the questions. Okay, thank you very much.
Thank you. Congratulations for keeping the time, 17 minutes. Ladies and gentlemen, first for presentations, please keep in mind what was said. The use of armed force, for instance, was the issue, but what to do with the use of so-called green uniforms and stateless people? What will be the answer for this kind of Is this aggression or maybe intrusion or something else? So some fruits for our further thinking. We will have a discussion after the presentations. As an absent-minded person, I didn't present it to people sitting here with us, but all clever people recognize that they are waiting, standing by, ready to fight in the second part of our panel. But of course, you are kindly invited, both Mrs. Grebik and Professor Stanmura, for a discussion if you are ready to do that. Second participant in our panel, this famous Palermo again. So we are looking forward because this is a proper perspective, I suppose, for our discussion this afternoon.
Yeah. So thanks, first of all, to the organizers for the invitation. It's a pleasure to be here. And secondly, yes, I think that I will, in the time that I have, I will deal with some of the problems concerning the legal regulation of the use of force, essentially with one problem, which is the impact that the absence of military confrontation has or should have on the legal characterization of military action under general international law. This is a point which has been raised, as you all probably know, by President Putin in his famous Crimean speech on 18 March 2014, when he pointed out that there's never been an aggression without a single shot being fired and without human casualties. And I think that this is this creates and this raises a true legal question, a question which is far from being trivial, even if I try to show that it's not totally decisive. So we all know that UN Charter uses three different terms. Speaks of force, speaks of aggression, speaks of armed attack. So my aim here is to see whether and to what extent the absence of military confrontation does play a role in the legal characterization of these three different categories. Naturally, starting with the notion of force under general international law. Here the problem would be, is there such a thing as a gravity threshold below which the prohibition on the use of force enshrined in Article 2.4, paragraph 4 of the UN Charter does not apply? In this regard, there are two theses. According to a first trend of legal scholarship, the international prohibited use of force requires the actual use of military weapons. Otherwise, an armed intrusion would be more likely to be characterized as a violation of sovereignty, but not as prohibited use of force. On the other hand, another strand of scholarship embraces a sort of more contextual or eclectic approach, according to which, in order to set aside Article 2, paragraph 4 of the Charter, it's not enough to claim that no fighting took place. This is just one of the criteria to be taken into account, together with many others, to assess whether there has been or not an unlawful use of force under general international law. For instance, this is a position defended by Olivier Courtin, who speaks also of the place, the context, who decided the action, the target, the scope of the means implemented. In brief strokes, this is the general picture. How does the Crimea case can be accommodated within this general framework? Well, we all know that at the very beginning of the crisis, it was not entirely clear whether we were experiencing a prohibited use of force. We didn't know who were the unidentified armed men who were carrying out military operations in the Crimea. As the days went by, both the UN Deputy Secretary General and the UN Assistant Secretary General for Political Affairs, in their briefings before the UN Security Council, affirmed that there was some sort of involvement of Russian troops, and I quote, Russian troops from on the briefing of the UN Assistant Secretary General to the UN Security Council of 3 March 2004. In this regard, probably the most reliable evidence of the occurrence of use of force in international relations was the fact that Russia itself found it necessary to immediately provide a justification for what was going on in Crimea by invoking, as my colleague was previously recalling, by invoking typical justifications of the use of force, the consent, protection of nationals abroad. With time, the main argument became the necessity to guarantee the free expression of the will of the Crimean population, so to guarantee the exercise of self-determination. This became the main pillar of the Russian argumentation. With regard to this, I would say that in the legal commentaries that have been published so far in the Crimean crisis, probably there is one question which has gone kind of unnoticed, which is the problem not only whether the Crimean population was entitled or not to exercise self-determination, remedial secession, so forth, and so on, and everything that has been already dealt with in the previous session, but a different question, which is, even assuming that there was a right to self-determination, are third-party states entitled to use force to support a fight for self-determination under general international law? And here, if we regard to the history of implementation of the principle of self-determination, for instance, in the framework of the historical process of decolonization, what we have? We have different positions. There were some states, at that time probably the Soviet Eastern Bloc, who was rather in favor of the possibility of justifying the use of force in support of struggle for self-determination, and the Western Bloc, who was rather against this possibility. What was the result? The result were some provisions included, for instance, in the Declaration on the Friendly Relations among States, Resolution 2625, then repeated in Resolution 3314, the Declaration on Aggression, provision where we find the following statement: every state has the duty to promote realization of the principle of self-determination in accordance with the provision of the Charter, where by this in accordance, naturally, the prohibition of use of force was meant by. And another provision where it was stated that in pursuit of the exercise of self-determination, such peoples are entitled to seek and to receive support in accordance with the purposes and principles of the Charter. This means that the compromise which was struck between these two different positions, those who were in favor of the use of force to support self-determination and those who were against, was the idea that peoples entitled to self-determination had the right to struggle, had the right to seek and receive support, but in accordance with the principles of the Charter, always starting with the prohibition on the use of force. If we look at practice, we find some UN General Assembly resolution commending frontline states supporting national liberation movements who were fighting against racism, mainly in Namibia, but in those cases, these were all instances of indirect use, what might be characterized as indirect use of force, which means it was only the assistance, military assistance or infrastructure given to these national liberation movements who were fighting against racism, but never the possibility to be directly involved by military operation in support of struggle for self-determination has been positively considered and assessed within the UN bodies. Aggression. Aggression, we have here Article 3E of the definition of aggression, which very simply tells that the mere extension of the presence of foreign armed forces in contravention of agreed conditions qualify as aggression, which means that military confrontation is not directly required in order to qualify an act as an aggression. Even mere naval blockade, even if not maintained effectively, which is by opening fire, can qualify as aggression. So it would seem that both to qualify an act as a use of force or as an act of aggression, pursuant to Resolution 3314, military confrontation is not in principle required. Finally, one last question. Does the lack of military confrontation hinder the characterization of a military operation as an armed attack? And here, Crimea is interesting because, to the best of my knowledge, the only reference to the right of self-defense acknowledged by the UN Charter under Article 51 made in the 20 days or so of the Crimean crisis is contained in an address of the Ukrainian parliament to the United Nations dated 13 March 2014. However, in this address too, Russia was accused of, and I'm quoting, of an unprovoked act of aggression, end of quote, rather than an openly stated armed attack. For the rest, these two words, armed attack, remained absent from the debates held at the UN Security Council, nor do they appear to have been used in other contexts. In legal terms, there are two different ways to make sense of this. According to a first line of thought, aggression and armed attack are the two sides of the same coin. In both cases, a threshold of gravity must be met in order to qualify use of force as either aggression or armed attack. On the other hand, according to the view held by the majority of the scholarship, the text of the UN Charter, the travel of the Declaration on Aggression, and customary practice generally show that a cascading relationship exists between force, aggression, and armed attack used in the UN Charter, whereby the latter concept, which is armed attack, constitutes the narrowest of the three. If we look to the ICJ case law, Nicaragua and oil platforms, it indicates the existence of a requisite of gravity, which is inbuilt in the notion of armed attack, which is based on the idea of scale and effect. As a consequence, the notion of armed attack would require, according to some authors, the infliction of substantial destruction or a considerable loss of life and extensive destruction of property. Given the fact that these effects have not been experienced in the case of Crimea, one could be driven to conclude that the Crimean case finally explains how to chop the line between aggression and armed attack. On the other hand, however, customary practice makes it clear that the gravity threshold of an armed attack should not be set too high. It is very flexible. This is confirmed by the ICJ case law. In the oil platform case, the ICJ did not exclude, and I'm quoting, the possibility that the mining of a single military vessel might be sufficient to bring into play the right of self-defense. And previously in the diplomatic and consular stuff, the ICJ went so far as to speak of armed attack, though not for the purpose of self-defense, with reference to the seizing of the American embassy in Tehran by Islamic militants. After all, it could be argued that any assessment of gravity, the notion which is inbuilt in the very idea of armed attack, also depends on the assessment of the effects of military operations, and that the assessment of the effects of military operation on its turn include the assessment of the importance of the legal interests and the sovereign rights which have been affected, regardless of the destruction which has been provoked. In conclusion, one is here led to think that the choice to characterize the use of force in Crimea in terms of aggression and not of armed attack finds its main rationale in the political will to limit the consequences to the law of state responsibility rather than to the law of the use of force or self-defense. From a more legal point of view, I would simply point out that to hold otherwise, which means that to make the applicability of the prohibition of use of force conditional on the fact that military operations result in actual armed confrontation, would be tantamount to putting the cart before the horse, in the sense that the actual reaction of the territorial state who maybe is put in the condition not to react, or it's in conditions of inherent military weakness, well, the reaction of the territorial state would determine the legal characterization of the trespassing state's initial act. Thank you very much.
Thank you very much. Well, I suppose this was a perspective from the outskirts. Please put your attention, Donbass or Eastern Ukraine was not mentioned. And the Crimea issue, this statement, the armed attack versus aggression, is the two sides of the same coin. And on the other hand, on Crimea, there was no victims. No victims means no military actions leading to the victimization of the local population. I suppose we have an open floor for a very harsh discussion in front of us. But before that, the third panelist, Professor Henderson, representing UK. If you wish to take this one, if you wish from here, please go ahead. Thank you.
Okay, thank you, Chair. Talking of chairs, actually, these are far too comfortable for the post-lunch slump, I think, because one or more of us may end up dozing off at some point. So I'm going to lean forward just to make sure that I don't fall asleep. No, they are very nice. Okay, I'll try and keep within time. I've already bribed the chair to allow me a few extra minutes. I wasn't actually told that it was 15 minutes, so I was sort of prepared for between 15 and 20, so hopefully I'll land bang on the 17-minute mark.
Depends from the content.
Okay, well, let me dazzle you then. Okay. Okay, well, I think we've already heard quite a lot about the crisis in Crimea, and we've also realised that it's created quite a lot of reverberations, if you like, for international law, for the international legal system, for different rules and norms involved. And the debates about whether one state or another has violated international law filled the pages of the media, have filled blog pages, and it's also a really good example of how international law and questions about international law have stretched beyond the sort of academic and diplomatic realm, if you like, to the public realm. And the public are now informed about, or misinformed as the case may be, about issues of international law. So it's a really big issue, and it's something which I think is good in that sense, the fact that it has become so public. But what's really struck me about this whole Crimean crisis is the lack of clarity surrounding some of the actions involved in terms of classifying them. So I don't want to sort of tread on Antonelli's toes too much. There will be a little bit of overlap here. I'll try and make it as distinctive as possible. So while many states and organizations have termed Russia's acts as aggression, John Kerry, the US Secretary of State, has even gone as far as to call them a brazen act of aggression. Other states have called them military intervention, a violation of the prohibition of the threat or use of force, and a clear violation of the sovereignty and territorial integrity of Ukraine, just to name a few. So there's various ways in which it's been classified, okay? It's also quite striking that they haven't been classified at any point, at least not that I've found, as an armed attack. And for some of you that will be of significance, for others it won't. I think Antonello sort of drawn out the significance of that, but I'll do so very briefly as well. So I don't want to dwell too much upon the rights and wrongs of those involved in this particular conflict. I know that's something which has been debated and will be debated further in this particular conference. But what I want to do more is look at the difficulty in legally classifying the events and applying the law in this area, but also to ask the question about whether making such legal distinctions ultimately really matters. So before going any further, what I'd like to do is just sort of give you a brief typology of force, if you like. I think, again, Antonello's sort of done that a little bit already. And in particular for our gentleman over there, is he there anymore? The non-international lawyer? No, he's professing his new knowledge of international law. Just to sort of try and make things a little bit clear about how force is set out, in theory at least, and then I'll try and confuse you all with how it's been applied in the Crimean crisis. So while states may interfere in the affairs of other states, the International Court of Justice has opined, and there doesn't really seem to be any dissent on this view from other states or scholars, that this interference only really crosses the threshold of illegality, if you like, when it takes on a form of coercion, to use the words of the ICJ. So that political, economic, cultural, social choices are no longer made freely. However, and as the ICJ also set out, while many forms of intervention can be undertaken through peaceful or at least non-forcible means, a particularly conspicuous form of intervention is the use of force, and more specifically, armed force. But of course, this can be divided up even further. We can have direct force, for example, one state's army crossing the border of another state. That's pretty much a good example of direct force. Or we can have indirect force. So, for example, like what Paul was mentioning earlier in the definition of aggression, where one state supplies arms or military training to the non-state actors in another state, or sends them into the territory of another state to carry out actions of a particular gravity. Okay. Yet, intervention of a direct nature can be witnessed in different ways, with different consequences attached here as well. Because while we might have the firing of a shot across a border of one state into another, it also may mean, as I said before, the crossing of a border by a state's armed forces, a massive land invasion, if you like. Now, the ICJ declared that these types of force can be distinguished through their gravity, with those of particular scale and effects legally constituting something more than just a use of force. So in other words, they constitute an armed attack. Okay, and as Antonello mentioned earlier, armed attack is sort of seen as the sort of pinnacle, or the most heavy of the different types of uses of force. Now, making this distinction is important as well. A state may suffer a use of force, either of an indirect or direct nature. It is not permitted under this framework to respond with force. And it's only when the force can be characterized as an armed attack, because of its gravity, that it becomes permissible to respond in self-defense. Okay, the final type then is aggression. Okay, and we've heard quite a lot about aggression already. And this appears in the UN Charter, at least, in the context of opening the door to the UN Security Council to resort to enforcement measures of either a non-forcible or forcible type. And of course, the UN General Assembly adopted the resolution containing the definition of aggression in 1974, which looks, on the one hand, to be very similar to Article 2.4 in the way it defines it, but then starts to draw in these concepts which the ICJ has drawn upon to define what an armed attack is. So my point here is this is all quite confusing. So, the Crimean crisis. Well, at the beginning of the Crimean crisis, the movement of Russian troops outside of the bases in Crimea appeared to provide the conditions and space, at least, for the pro-Russian rebels and local authorities in Crimea to displace the Ukrainian authorities located there. And one way in which these events were characterized was as a form of political coercion, meaning that the political choices were not freely made by the Ukrainian people, and thus constituting an unlawful intervention. Okay, so we can perhaps sort of tick that box. On that basis, perhaps it might not then be an uncontroversial leap to claim that the naval blockade of the port of Sevastopol by military units belonging to the Russian Black Sea Fleet and the seizure of a number of Ukrainian military bases and border posts by the Russian servicemen, to use the way in which President Putin described them, was a form of military coercion, despite no shots actually being fired. Indeed, it may be easily contended, as many did at the time, that under the schema that I've already set out, a prima facie prohibited use of force had occurred, right? Well, not exactly, as it has been contended, as Antonello pointed out, that the actual firing of military weapons, the actual firing of shots, is a requirement for a use of force. That's one view. The other view, of course, is that it's a more contextual question. So we have to look at things like whether the military was used, whether it was the actual firing of weapons, a combination of both, or perhaps other factors, the identity of the perpetrator, the identity of the victim, and the circumstances of the particular victim. So while much is made of the idea that the prohibition of the threat or use of force is a, or perhaps the most fundamental norm within international society and international law, the Crimean conflict highlighted all too clearly, I think, that this is a difficult proposition to sustain when we are not entirely sure even when it has been violated. But while this is unclear as a question of international law, we could also just ask the question, well, who cares really? Who cares whether something's an intervention or a use of force? This may seem sort of quite flippant and provocative, but it seems to me beyond possibly a larger frown etched upon the faces of the international community, there is very little difference, at least legally, in terms of the consequences involved. Indeed, whether a state is responsible for a violation of the prohibition of intervention or that on the use of force does not appear to legally matter too much. But if this lack of clear and objectively verifiable criteria separating unlawful intervention from an unlawful use of force is a little concerning, then perhaps even more so is that the same can be said for the distinction between a use of force and an armed attack. Upon the scheme as set out previously, while the former does not permit a forcible response, the latter does under the right of self-defense. And also, as previously mentioned, the distinguishing factor here, and also as mentioned by Antonello, is the gravity and scale and effects of the force used. But this is a distinction that has been rightly criticised as being so vague as to the point of being irrelevant. On the one hand, if one looks at the jurisprudence of international courts and tribunals, we can see that the threshold of gravity is probably quite low. Some of the examples that Antonello pointed out, I think, highlight that quite well. And these cases, I think, really suggest that the de minimis threshold, if one exists in general, is low. But this is, of course, if it exists at all. We must bear in mind that this gravity threshold is a construction of the ITJ. It's not something which states have necessarily devised, although they haven't also necessarily departed from. Dame Rosalind Higgins, amongst others, and let us not forget, she was a president of the International Court of Justice for a time, has essentially claimed that the distinction between force and armed attack is, not to put a too fine a point on it, simply a legal fiction. She essentially dismissed the gravity distinction criteria and thereby the difference between a use of force and an armed attack and whether distinguishing between them really matters. And instead placed the focus upon the level or the proportionality of the force used in response. But while the need for a specific gravity for the use of force, and if so, to what level, is in doubt, it is, like with the use of force, also not clear whether the actual use of kinetic force, that is, the firing of a military weapon, is required for an arms attack to be determined. Indeed, President Putin made much of the fact that no shots are actually fired at the beginning of the Crimean crisis. So is kinetic force actually required for an armed attack? If we are to give it a negative response to this, 5 minutes, okay. Then we're effectively saying that Ukraine did not have a right of self-defense, despite a significant amount of foreign troops upon its territory without its consent, which were carrying out hostile acts towards it to the point of annexing a part of its territory. So to say that self-defense was not permitted would sit rather uncomfortably with the fait accompli that appeared to be forcibly imposed by Russia. And in this respect, the possibility that a state may be held responsible for an arms attack, even without opening fire, has not been ruled out. We have certain scholars, Joran Dinstein being one, saying in many circumstances the opening of fire is an unreliable test of responsibility for an armed attack and looks more at invasion or arms blockade. But while determining the occurrence of an arms attack is important, as it arguably draws the line over which a forcible response may be lawful, we have to bear in mind that neither Ukraine nor any other state characterized Russia's actions as an armed attack. Well, not exactly. You see, on the 28th of August 2014, Ukraine claimed at the UN Security Council that, in view of the open Russian military aggression, Ukraine reserves its right to act in accordance with Article 51 of the United Nations Charter, which empowers every member state of the United Nations to act with its inherent right of individual or collective self-defense if an armed attack occurs. So we could say that it has either implicitly characterized the actions as an armed attack through the invocation of the right of self-defense, or that it simply did not mention armed attack due to fears of escalating the conflict. Indeed, unlike with the concept of collective self-defense, the victim does not need to declare itself specifically as a victim of an armed attack. But wherever one goes with the debate, it's clear that Russia's actions were characterized as an act of aggression by Ukraine, by the Council of the European Union, by various other states in the Security Council debates. This seemed to be the one that they focused on mostly. And as Paul mentioned earlier, there are various ways in which we could place the actions of Russia within the definition of aggression. Okay. Now, I'm going to skip over going over that because I don't think we need to do that anymore.
Please do.
I will, so I'm not dazzling you, obviously. But what is important here is not only the impossibility of distinguishing an armed attack from aggression under the definition of aggression, but also the way in which it provides a certain flexibility to states in trying to determine whether one has actually occurred. For example, while a forcible response is specifically limited to responding to an armed attack, as this is often perceived as the most serious form of the use of force, in the preamble of the definition of aggression, aggression is characterized as the most serious and dangerous form of illegal use of force. Furthermore, if indeed, and as discussed above, we are to attach a distinction between a use of force and an armed attack based upon the gravity of the acts concerned, it is significant that Article 2 of the definition states that the UN Security Council may refrain from determining that an act of aggression has occurred if the acts concerned or their consequences are not of sufficient gravity. Now, similarly, Article 3G states that an example of aggression is the sending by or on behalf of a state of non-state actors which carry out acts of armed force against another state of such gravity as to amount to the acts listed above. Now, while the ICJ also qualified its use of this in the Nicaragua case with the requirement of gravity, as we have briefly touched upon already, this gravity requirement is vague, minimal, or perhaps even non-existent, perhaps leaving the door then open to the accusation that this form of indirect force was not only a form of indirect aggression, but also an indirect armed attack, and by implication, an indirect use of force and an unlawful intervention. So, confused? I certainly am. And I think ultimately, however, the definition makes clear that the question as to whether an act of aggression has been committed must be considered in the light of all the circumstances of each particular case. And I think given the wide variety of circumstances that each side in the debate may ultimately draw upon, it is perhaps a question which will ultimately remain unresolved in almost all cases. But if we are then to say that the fact that the Russian actions have been determined to be aggression means that they are by implication to be considered an armed attack, this leaves us with the question as to why no real effective action was taken at the time or subsequently to either reverse the annexation of Crimea or to punish Russia for such a significant violation of the law. And just to conclude, just 1 minute, I think we also just have to be clear that there is a distinction to be made between banding terms around indiscriminately, as perhaps is arguably the case here, and when the law itself is indeterminate. Okay. That's the distinction I think we have to make. I think the discourse of the use of bellum is in many respects undisciplined in this sense, and we can see this throughout. So I don't think that necessarily that we're going to resolve this particular issue. I think a lot of this comes down to the UN Security Council, the functionality of the UN Security Council, enforcement of international law more generally. And given that the international community's experiments with collective security have continued over centuries, the fact that state sovereignty still takes precedence on most occasions over any feelings of responsibility upon the international community to take collective action, and of course the perennial issue of sovereign inequality, I think the law governing the use of force may never be able to sort of really truly realise its full potential. Thanks very much.
Thank you. And also thank you for skipping some arguments and definitions. We had a lot of them. What is direct force use, indirect force use, an act of aggression, and an act of coercion. But there's a question behind all of it. What is the difference between all those definitions and all these descriptions if the final result is the change of the territory of the state. This is the issue for our discussion. Finally, the final words as promised to the Russian side, to Professor Evgeniy Voronin. As you know, he was already to discuss representing the Sicily, so now he will represent the strong Russian side. Your floor is yours. If you want to stand, you can stand. If you wish to sit, and go ahead. Full steam, please.
Thank you. Ladies and gentlemen, we had today extremely interesting reporters and discussions, but nobody mentioned one thing, namely, what was the main cause that led to the present existing situation in Europe, situation in which our international law actually does not function effectively. What was the main cause of the situation in relation between Russia and Western partners? What was the cause that actually destroyed heritage in many things, heritage of Helsinki Final Act? What we have today, what the system we have today after this main cause which happened, this main cause, absolutely unexpectedly, it is namely the coup d'etat in Kiev. It is the main cause. In February 2014, the state power in Kiev was taken over through forceful actions of armed people rather than elections. The president of Ukraine, elected in accordance with the constitution, had to leave his country. It was actually clear it was the first illegal overthrow in Europe since the end of the Cold War. It is the first coup d'etat in Europe in our time. The power was taken by a group which based their actions not on the elections result, not on the law, but on the will of Maidan. And it is happening in the zone of rule of law of Europe. A significant part of the citizens of Kiev and Ukraine as a whole, especially in its central and western regions, unsatisfied with the economic situation during the term of the previous president of Ukraine, consistently supported the takeover. This silence could be meant the support for nationalist politics of the new authorities in Kiev, as well as the approval of the rapprochement with the Western military and economic structures. The southeastern regions of the Ukraine didn't recognize the regime of this Panov Turchinov Yatsenyuk, which came to power through the takeover as illegitimate. Actually, in February 2014, the people of the Ukraine became split in two. Ones who recognized the mutiny and those who didn't. The situation resulted in the civil war. As well known, the mere fact of the coup d'etat in Kiev is ignored in various Western countries. Important, which is omitted by our partners, is a violation of Article 5 of the active Constitution of Ukraine, which states that no one can usurp the power in the state. And now, the practice of this clausule of this article, well known, the previous president of Ukraine is in exile, and you know in what country. Please understand me rightly. I'm not going to defend any foreign president, including the Ukrainian president, but it is only a matter of fact. Article 17, Article 9 of the Constitution is also ignored, but it says that the rule of law is a principle acknowledged and abided by in the Ukraine. But the Western counselors and advisors maybe didn't notice that, the violation of this constitution, this clause of this constitution. Article 17 of the Ukrainian constitution is also infringed. It states that the armed forces of the Ukraine and other paramilitary or something like that formations can be used to restrain the rights and freedoms of the citizens. In scope of these rights, the citizens didn't recognize the illegal overtaking of political power in Kiev, in capital of the Ukraine. But in Kiev, this fact is ignored as well, while ordering the armed forces fight against their own Ukrainian citizen, I emphasize, in the southeastern regions. The Ukrainian constitution interdicted creation and functioning of any military groups on the Ukrainian territory, not provided by the law. The Ukrainian oligarchs, so we know everybody what does it mean, oligarchs, Novorish, yeah? Actually violated this provision by forming the nationalistic armed groups, so-called unofficial volunteer military battalions, Azov, Aidar, etc., and the last time very active right sector armed political party. Another violation on article of the 10 of the Constitution, which determines that free development, use and protection of the Russian and other languages of national minorities are guaranteed in the Ukraine. The Bolzano recommendation, as we know, adopted in the framework of OSCE on the right of national minorities, including, safeguard of the culture, language, etc., are violated as well. Article 5 of Ukrainian Constitution prescribes that the censorship is banned. But what we have in reality does exist, which is backed up by many facts, including the physical mutilation of the mass media reporters, which tried to cover in the news the events in Kiev after the Maidan overthrow. And now some words concerning the Russian Navy in the Crimea. I don't want to repeat because it was said so many things, right, and not very right. But at any rate, I tried to touch this theme in some words. The Russian Navy had been stationed in the Crimea according to international law by the time to overthrow in Kiev took place. None of the states had even questioned the legitimacy of the centuries-long presence of the fleet in the Crimea. More specifically, the Russian Navy was in the Crimea for centuries due to historically entrenched legal fundamentals, including those affirmed by international agreements of the Russian Empire and Soviet Union. If you permit me, I'd like to remind you what I mean. The Russian Navy presence based by the provisions of the concluded international treaties between Russia and Ukraine. First of all, status in terms of presence of Black Sea Fleet in the territory of Ukraine, because it was not some aggression, some new elements, military elements, which we see today, for example, in Ukraine. Second, mutual payments, second agreement, mutual payments related to the partition of the Black Sea Fleet and presence of the Russian Black Black Sea Fleet in the territory of the Ukraine and partition parameters of the Black Sea Fleet in accordance with international law. Some words about the transfer of Crimea to Ukraine, because this is a topic which is not very well known in the world, in Europe especially. And I don't know what about the United States, and so, but you're not very well known. The transfer of Crimea in 1944 from one of the Union republics, that time Russian Soviet Federation, into the administrative subordinacy of the other, the Ukrainian Socialist Republic, had no international legal implications. This transfer was conducted in one state, one subject of an international law, the Soviet Union. No new state boundaries, maritime or overland, were created. The regions of internal sea waters, territorial waters, continental shelves adjoined to the Crimea didn't change their legal status, and the state administration was conducted, you understand, from Moscow. The transfer of the Crimea didn't comply with the Soviet legislation of that period. I emphasize, didn't comply with the legislation of the country. The decision of the Soviet leadership on the transfer of the Crimea from Russian Federation to the Ukrainian Republic violated the Constitution article of the Soviet Constitution of the 1936, that the territory of the Union Republics can be changed without the consent of these republics. There were no corresponding procedures, referendum other procedures, etc., which would allocate the consent of the Russian Federation as well as the consent of the Ukrainian Republic. Signing the treaty by the President Yeltsin and Kravchuk on the matter of including the Crimea into the Ukrainian Republic in 1991 violated the fundamental principle, the right of nation of self-determination, UN Charter, Article 1, etc. The consent of the Russian President on transfer of the Crimea on the Russian President on transfer of the Crimea to the Ukraine took place without the expression will of the people of the Crimea. I would like to emphasize one thing, the final element of my remark, of my report. In 20 years period of the illegal including of the Crimea into Ukraine, sanctioned by the Soviet leadership, no legal title has been formed for this region. Example, and at the end I would like to lead one interesting example. To my mind, this example is very, very similar as we have in the case of Crimea. I mean the reunification of northern Schleswig with Denmark. And in Denmark there is a motto, no Denmark without Schleswig, no Schleswig without Denmark. And this reunification based on the plebiscite in 1921, despite the fact that this region was part of the Germany Prussia after for the 60 years after the victory of Bismarck over the Denmark. As another evidence, that's all what I can say for today. But now at the conclusion, three little elements. There is a national consensus about the reunification of Crimea with the homeland, Russia. It is act for eternity, will be never back. It's clear, and no hopes to have no no legal basis for that, for the returning. Absolutely excluded. Second, the consciousness of the people, Russian people in Crimea, is great Russian national memory, not Ukrainian. Not Ukraine. There is no national Ukrainian memory because Ukraine is a new state. Because we are support Ukrainian state as an integrated state, as a federal state. It's no problem. And the final, concerning sanction. Sanction against Russia is useless. And the target will be not reached because we know that Russia survived more difficult times than today. We don't regard this time is very difficult, but at any rate, not pleasant, of course. Of course, we have lack of the Polish apples, for example, but we try to buy the apples. Yes, so many markets, so many garden countries like Poland, which is try to send apples to us. That's actually. Thank you all.
Thank you. Interesting presentation, different perspective. As I mentioned, self-described myself, I'm not a lawyer, and so to my mind, this was a philosophical question here raised here. Typical, what was the first, the hen or the egg? Because the Crimea, and here was the presentation that the coup d'etat in Kiev. So we have time for discussion.